Each of the 5 justices of the Constitutional Court sitting in Mbale High Court read their individual judgments in a process that went on for over 13 hours.
For 5 years, and then go for a re-election.
All the justices concurred with the petitioners that lawmakers exceeded their mandate in amending the Constitution to extend the term of Parliament from 5 to 7 years without consulting their voters, the Ugandans. The justices noted that Ugandans have absolute power to choose who leads them, and the social contract the MPs signed with them was for a 5-year term that can only be changed after consulting the voters. On the reintroduction of the presidential term limits, all the justices agreed with the petitioners that Parliament did not follow the proper procedure in reinstating the presidential term limits.
There would be no limits to their demands. Nothing would stop them from amending the Constitution, provided that they would be members for life upon death. Their parliamentary seats would be inherited by their children.
I would therefore strike out sections 2, 5, 6, 8, 9, and 10 of the Constitutional Amendment Act 2018, which provide for the extension of the tenure of Parliament and local government councils by 2 years.
I find that the consolidated petitions have succeeded on the issue of seeking declarations to be issued that the extension of the term of Parliament and local government council from 5 to 7 years, and also that the reinstatement of the presidential term limits are unconstitutional.
On the removal of the 75-year age limit for one to stand for president, 4 justices concurred with the respondents that Parliament followed all the required procedures in tabling, debating, and passing the bill.
Parliament followed all the procedural requirements in the Constitution, Acts of Parliament and its rules of procedure. There was a bill, consultation was carried out, the bill was gazetted, the bill was read for the first time, and it was referred to the appropriate committee.
Articles 102 and 181 are not among the entrenched articles, and the amendment did not infect any other provisions of the Constitution.
The only dissenting Justice Kenneth Kakuru quashed the entire act on grounds that Ugandans did not meaningfully participate in the process, saying MPs did not conduct adequate consultations on the bill.
The entire Constitutional Amendment Act of 119 of Act 1 of 2018 is unconstitutional and therefore null and void. All its provisions ought to be expunged from the Constitution of Uganda.
Erias Lukwago, who represented 6 members of Parliament, says they will appeal the decision of the justices on the removal of the age limit.
It wasn't red. I think it was a yellow light, which is either stop, halt, and wait, and what not. So it was ambiguous. That kind of ambiguity is what we want to deal with at the Superior Court.
There are so many silent issues that we had raised that this court conveniently dodged and did not handle. One of the requirements of our rules of procedure is that any bill that is referred to a committee must be handled within 45 days. As you heard from this court, this bill took more than 85 days before the committee.
Whether we abide by the ruling as it is, or whether we seek another opinion, but speaking for myself, having gone through the process, I'm extremely happy with the verdict.
As things stand now, unless overturned by the Supreme Court on appeal, the judgment means that President Yoweri Museveni is now constitutionally eligible to stand in the 2021 presidential elections, and others to come as long as he is able and willing. By 2021, President Museveni will have reigned for 35 years.
Court will rise.
Habad Ziwa, NTV.